The day my grandfather's lawyer handed me the ranch deed, everyone thought I'd inherited nothing but dry land and broken fences. The property had been abandoned for decades, hidden behind overgrown mesquite trees and forgotten county roads. To everyone else, it looked worthless. To me, it was still family. For nearly 6 months, I worked from sunrise until sunset restoring the old ranch. I repaired fences, rebuilt cattle pens, and cleaned barns one board at a time. Most of the people living next door in Oak Ridge Estates laughed whenever they drove past. One afternoon, 2 geologists arrived carrying old survey maps and drilling records. They explained that new satellite data suggested there might be something valuable buried beneath my land. I agreed to let them conduct a geological survey. 3 weeks later, the test results came back. The lead geologist smiled, unfolded the report, and told me the ranch sat above one of the largest untapped oil reserves in the county. My quiet little ranch had suddenly become worth millions. Within days, news spread across the county. Oil companies, investors, and land agents lined up outside my ranch, each hoping to negotiate drilling rights. The same neighbors who once ignored me were suddenly waving every time they drove past. The following Monday, I received a certified letter from the Oak Ridge Estates HOA. According to the letter, the association believed it had a legal interest in the underground oil because the reservoir extended beneath parts of the neighboring subdivision. I read the letter twice, thinking it had to be a mistake. A few days later, I attended a meeting at the Oak Ridge Estates clubhouse. The HOA president confidently claimed the community deserved a share of any future oil revenue because the discovery could increase neighborhood property values. Without raising my voice, I placed my grandfather's original property deed on the conference table. The yellow document clearly showed the ranch and its mineral rights had remained in my family's ownership for generations, long before the subdivision existed. Victoria wasn't impressed. She pushed the document aside and announced that the HOA had already hired a team of expensive attorneys. She insisted they would prove the oil belonged to the entire community, not just my ranch. The room fell silent as everyone waited for my response. I didn't waste time arguing. The next morning, I drove straight to the law firm that had represented my grandfather for decades. They immediately began pulling county records, mineral rights filings, and historic surveys to build an airtight case before the HOA could make another move. Over the next 2 weeks, my attorneys uncovered records that hadn't been opened in over 70 years. Every deed, survey, and mineral agreement pointed to the same conclusion. The oil rights had always belonged exclusively to my family's ranch. The HOA's claim had no legal foundation. Just as we finished reviewing the documents, an oil company executive called with incredible news. Their engineers wanted permission to begin exploratory drilling immediately because the test results looked even better than expected. Things were moving much faster than anyone anticipated. Within a week, heavy equipment rolled onto the ranch under signed agreements and county permits. Survey crews carefully marked drilling locations while engineers inspected every acre. Everything was being done by the book, leaving no room for legal challenges. Within a week, heavy equipment rolled onto the ranch under signed agreements and county permits. Survey crews carefully marked drilling locations while engineers inspected every acre. Everything was being done by the book, leaving no room for legal challenges. Frustrated, Victoria called the county planning office from the side of the road. After a long conversation, she learned that every permit had already been approved months earlier. For the first time, she realized the HOA had no authority over what happened on my ranch. Frustrated, Victoria called the county planning office from the side of the road. After a long conversation, she learned that every permit had already been approved months earlier. For the first time, she realized the HOA had no authority over what happened on my ranch. The discovery made headlines across the state. News crews, photographers, and reporters filled the entrance to my ranch, eager to cover one of the biggest oil discoveries in years. Overnight, my quiet property became the center of everyone's attention. Watching the television coverage from her office, Victoria became even more determined. She scheduled an emergency HOA board meeting and announced that the association would file an immediate lawsuit to stop production before the first commercial well could begin operating. A week later, my attorneys informed me that the HOA had officially filed its lawsuit. Fortunately, they were already prepared. Every permit, survey, and ownership record had been organized into thousands of pages of evidence ready for court. On the morning of the hearing, I walked into the county courthouse knowing the facts were on my side. Victoria arrived moments later with her legal team, confident that the HOA would take control of the oil rights. Neither of us knew how quickly the judge would settle the dispute. Inside the courtroom, both sides presented their opening statements. My attorney explained the chain of ownership, while the HOA argued that the underground reservoir affected the surrounding neighborhood. The judge listened carefully, asking both sides to focus on documented evidence rather than assumptions. My attorney presented the original ranch deed, decades of county surveys, and recorded mineral rights agreements. Each document confirmed that the oil rights had remained attached to my family's property through every ownership transfer. The county surveyor was called as an expert witness. Using detailed maps and engineering records, he explained that property ownership and mineral rights were determined by recorded legal boundaries, not by the existence of a neighboring homeowners association. After reviewing the evidence, the judge ruled that the ranch and its mineral rights were privately owned exactly as recorded in the county archives. The HOA's claim was denied because no legal document supported ownership of my family's oil rights. As I stepped outside the courthouse, reporters surrounded me with questions about the decision.